Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you once again from our fantastic Central Washington location. Hey, want to talk to you, America, about a big ruling that came out yesterday. It's on an injunction, and it's going to keep a lot of you from having the ATF kick your doors in over the next couple of weeks. Now, you might think that's hyperbole, but this is the rule that deals with what it means to be engaged in the business of being an FFL. And if you don't believe me that the ATF takes this rule real serious and in fact will kill you for violating this rule, well then ask the folks at Ruby Ridge or Waco, Texas, or the family of Brian Manilowski. There has been an injunction. We're going to talk about that because it saves some of you, but it doesn't save all of you. So today, let's go through the ruling itself and let's talk about the huge ruling that will keep the ATF from kicking in some of your doors. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, America, this is what we're talking about. We are talking about the case of State of Texas et al. Versus ATF. This is a case that's filed in the United States District Court for the Northern District of Texas in the Amarillo Division. That is a mouthful. This is a challenge to ATF's new rule on what it means to be engaged in the business of selling firearms. Translation, how many of you actually need to get a federal firearms license in order to keep doing what you call a hobby? And the answer is if you look at this rule, it's just about every single one of you. So if you are a person that hangs out on Arms List and does some business there, if you're a person that's engaged in gun broker or things like that, I'm not saying there's anything wrong with your activity whatsoever. Unfortunately, the ATF doesn't see things the same way. Now, there has been an injunction, and this is really, really important, because I'm going to read the first paragraph of the ruling, which is going to talk about who actually enjoys injunctive relief, okay? Because it's not all of you out there. If you live in certain states or you're members of certain organizations, yes, you are solid. Here is the ruling of the court. Before the court is plaintiff's motion for a preliminary injunction filed May 9, 2024. Defendants filed their response on May 14, 2024. Having reviewed the briefing and relevant law, the court grants the motion. Defendants are hereby enjoined from enforcing the regulations, definition of engage in the business of a firearms dealer against plaintiffs Texas, Louisiana, Mississippi, Utah, Jeffrey Tormey, the Gun Owners of America, Inc., the Gun Owners Foundation, the Tennessee Firearms Association, and the Virginia Citizen Defense League pending the resolution of this lawsuit. But unless you are a resident of that state or a member of those organizations, you do not enjoy injunctive relief today. Now, I know that constitutes millions of people, but it does not constitute a massive, large swath of the American population. So again, if you are engaged in this sort of activity on Arms List or on Gunbroker or any other similar platform, I want you to very carefully watch your steps, because this is a rule that ATF will be allowed to enforce on some individuals. And for those of you who are wondering, geez, I wonder if I should join the Gun Owners of America or some of these other very worthwhile organizations, and there's that old adage that membership has its privilege, let me remind you how much members of organizations such as GOA, FPC, Second Amendment Foundation, how much they have benefited from being members of those organizations through the hard litigation work that those organizations have done. Now, one of the reasons we focus on preliminary injunctions on this channel is because it really does give us a good sign of where this litigation might go. Because if we break it down to its most simplest form, the plaintiffs have to show, one, that they're going to be irreparably harmed. And I will tell you that having ATF kick in your door and arrest you for being an FFL without a license or killing you for being an FFL without a license probably constitutes irreparable harm. The second thing, and this is what we focus on frequently here at Washington Gun Law, is that the plaintiffs must also show that they're likely to prevail on the merits. Now, we've been very, very worried about this rule because unlike most of ATF's rulemaking orders, which have absolutely no basis in statutory text whatsoever, let us not forget that the Bipartisan Safer Communities Act theoretically gave the ATF the avenue to do this. However, the trial court here said, no. Actually, we think this is in contradiction of the Bipartisan Safer Communities Act, and therefore, once again, the ATF is acting outside its lawful authority. The court has found 3 reasons by which they believe that the plaintiffs are likely to prevail here. Here, the final rule clashes with the text of the Bipartisan Safer Community Act in at least 3 ways. First, it asserts that there is no minimum number of firearms to actually be sold to be engaged in business for the purposes of the licensing requirement. A single firearm transaction, or even an offer to engage in a transaction, may suffice. But obviously, the court wasn't done there. Second, the final rule suggests that actual profit is not a requirement of the statute. It is only a predominant intent to earn profit through the repetitive purchase and resale of firearms that is required. In other words, a person may repeatedly advertise and display firearms for sale and therefore demonstrate a predominant intent to earn a profit from repeatedly reselling the firearms purchased, but never actually find a buyer. But the court points out even another problem with this rulemaking order. Lastly, the final rule creates sets of presumptions indicating, 1, when a person has the intent to predominantly earn a profit, and 2, that someone is engaged in the business. But these presumptions are highly problematic for at least 2 reasons. First, they flip the statute on its head by requiring that firearm owners prove innocence rather than the government prove guilt, which is absolutely true and actually renders the statute unconstitutional on its face if it involves criminal penalties. But the court also points out, second, several presumptions conflict with the statutory text. 2 of them, for example, provide that a person is presumptively engaged in the business if he demonstrates a willingness and ability to purchase and resell firearms or purchases or resells firearms. A mere willingness is not enough. There must also be prohibited acts. So what this means is while this matter is pending and before argument on the merits is made, any individuals who are in the class of individuals identified by this court cannot have ATF's new rule on what it means to be engaged in the act of being an FFL enforced against them. However, if you do not reside in one of those states, if you are not a member of one of those organizations, please be aware that as of today, that rule can be enforced against you. Now, just so we're clear, so you understand who is enjoining injunctive relief and who isn't. Once again, the list of the named plaintiffs that received injunctive relief include residents of the state of Texas, Louisiana, Mississippi, and Utah, members of the Gun Owners of America, the Gun Owners Foundation, the Tennessee Firearms Association, and the Virginia Citizens Defense League. If you do not reside in one of those states or are not a member of one of those organizations, please be aware that the rule could be enforced against you. Listen, we're going to go ahead and link up the order down below so that you guys can geek out on it for yourself. The case, once again, is State of Texas et al. Versus ATF. Listen, if you guys got ideas for videos that we should be doing here at Washington Gun Law, go ahead and click on that link right there. Some of the best ideas we ever had weren't really our ideas. If you got any questions about this or anything else related to what's left of your Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down below there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.